we'll call the meeting of the Rules Subcommittee to order. Will the clerk call the roll?
Chairman Kennedy,
Here.
Counsel Martin,
Here.
Counsel Madonza,
Here.
3 present.
Thank you. This meeting wasn't initiated by anybody on the subcommittee, and I think the purpose of the meeting is really just to do a review of the open meeting law. And so I turn it over to the city solicitor.
Sure. The mayor had mentioned, I think, when he had filed this motion, that he and I had both spoken to one of the attorneys at the AG's office regarding the open meeting law. And the purpose of the call was in part to sort of explore what their thoughts were about suspending the rules and adding things to the agenda, and how they may recommend other communities to address those types of things. Excuse me. During the course of the conversation, what was made clear is that it is their position that if something isn't on the agenda, unless it's something that is time sensitive, it should just wait until the next agenda. And also an issue was raised as to instances perhaps where someone might not have an opportunity. Say we had gone a couple of meetings without gathering, or a couple of Tuesdays without gathering, and so a member of the council might have been denied an opportunity to otherwise timely file a time-sensitive motion. Clearly, from our perspective as well, the open meeting laws are not designed to in any way strangle government or slow it down, but by the same token, balance it, obviously, with the needs of the public to know and have adequate notification of what's going to be on. As far as this issue coming before the Rules Committee, having worked with this current mayor, as well as past mayor, Jim Malinazzo, whoever, and you and I, Councilor Kennedy, had spoken about this last week, whoever ends up occupying the mayor's position and is left charged with running these meetings, it would be helpful, I think, to have the Rules Committee begin to weigh in on some of these issues, and perhaps establish some sort of guidelines for assisting whoever the chair of the meeting is for addressing some of these issues that may from time to time come up. So that, for example, if a member of the council were to make a motion to suspend the rules, maybe a standard inquiry into that would be, is this something, Councilor, that could just wait until next week? And if the answer to that question is in the affirmative, then that's in fact the course of action that maybe the Rules Committee would suggest be followed. And it's certainly one that would be well in keeping with the open meeting law. By the same token, if it was a time-sensitive matter and one in which a member wouldn't have otherwise been able to get it onto the agenda timely, that under those circumstances, the Rules Committee and the Council and the Chair would agree that an exception should be made and the issue be allowed to appear on the agenda. And maybe in those instances, in order to satisfy the open meeting law, maybe a good next step is to put that type of an issue on the agenda again the second week. That way, if there is somebody in a member of the public that wants to discuss it, they would still have an opportunity to discuss it, but at least the council has had an opportunity also to get the issue underway and begin to be addressed by the administration. So that was pretty much the gist of it, and again, I think that it may prove helpful if the Rules Committee had some thoughts as to guidelines for these issues to be addressed, so that there is consistency throughout the course of a term.
When a councilor moves for suspension of the rules, isn't the council supposed to state the reason for the suspension of the rules at that time?
Yes.
Yeah. And so the chair would be able to make a decision based on that usually. It shouldn't be that you ask for suspension of the rules and then spring something that's...
No, although I think there might have been instances also that we have encountered, maybe not necessarily with this council, but maybe with this council, where someone might state, this is the rule, because there's a good faith, this is the issue, good faith belief that this is what's going to be discussed. But from that, a number of other things end up being discussed either by the maker of the motion or by his or her colleagues. And again, I think it may be helpful if the committee took a look at the fact that if somebody were to make a motion to suspend the rules and they state the reason, instances where those motions should be allowed, and instances perhaps where an alternative method of getting something on the agenda should be sought. Ultimately, it's the chair, it's the mayor that's going to chair the meetings, but it certainly wouldn't hurt to have some sort of support, and actually, and if the mayor wants to jump in there.
Well, let me just ask, you said you had a conversation with the Attorney General's office.
Yes.
And so did the mayor. And I'm
Yes.
assuming that you initiated the call, not the Attorney General's office didn't probably call up here to ask how we were doing, right? It was.
No, yeah, right. Obviously, we had called to go over this, and it's something that is not particular to this council, but I think it happens during the course of any sort of given year.
Okay, so was there something, a specific incident or incidents that happened during the recent council meetings that caused you to call the Attorney General's office?
No, again, it's something that, and I'll let the mayor speak as well to this, but from my perspective, it's just something that I think by the very nature of the business of the council, councilors want to get things on the agenda. Things might occur from time to time that are not on the agenda, and certainly there have been several instances that we can probably all think of without even being able to pinpoint exactly what the subject matter was, but instances where we have suspended the rules and delved into a subject that wasn't necessarily on the agenda. So after that having happened a number of different times, we talked about it, and it was my suggestion that maybe we'll call up the Attorney General's office and just see what type of guidance they can give, if any. There really wasn't anything specific that they offered to us that we really weren't already aware of. But in any event, they said that there were some communities that they were having enforcement problems with, and they were talking about going through the process with those communities. And again, we're not looking at that in our community, but what we're really trying to do is to get a handle on it and take a practice and make it a good and sound one, and one that fully complies with the open meeting law.
Okay. Mayor Murphy, did you have something that you wanted to?
Sure. Thank you, Mr. Chair. Basically, this was something just was initiated really by myself and asked city solicitor to assist. Basically, to ensure that there was some kind of fairness, both in fairness to fellow councilors when a matter is brought up, and sometimes you have the case where not every councilor is aware of what's being discussed. They don't have a particular, document in front of them or a knowledge of a particular situation, but also in fairness to the public, to balance that and to keep within the open meeting law, and to try and apply that fairly and in a way that fellow councilors also agreed with and bought into, so that it's not just the chair who is enforcing, compliance with the open meeting law. It's each councilor realizing that we're working within a set of rules, and that it's up to each councilor to fully understand those and to stay within that.
Do you feel that there have been instances in recent meetings where the open meeting law has been a problem, or the way that the council has deliberated has been a problem with regard to the open meeting law?
Well, I think there have been times in the past where, prior to, you would ask for a specific example, but where there was an understanding that it would just be more of an announcement about some issue or discussion of an issue that sort of segued into a more substantive discussion of an issue where members of the public really should have the opportunity to come in and weigh whether they agree with that or disagree. And so it's, I think there have been occasions in the past where, there's been misunderstandings about what the law actually provides for, and that, it was really just something that I think we needed to get a handle on as a whole.
Yeah, I do. Let me just say, so there's been some, recent change in the open meeting law. It's not so recent now, but do you know when did the changes go into effect in the most recent revisions? Has it been a year, 2 years?
Actually, their most recent version is, came out February 10th of 2012.
Okay.
Some of the, excuse me, some of the more recent changes, one of the biggest impacts, I think, from a legal standpoint, as counsel to a municipality, really concerns our ability, in the administration ability, to be able to transmit information to the council in a otherwise confidential manner, which we used to be able to do. But now with the changes to the open meeting law, it's made very clear that any written communication to the council, if it doesn't occur in an executive session, excuse me, that communication becomes public. And obviously, as you know, there were other changes that were made as well. But that was one of the more significant changes.
Right. But there were specific changes about agendas, right?
There were specific changes about agendas and the discussions taking place that were limited to the agenda.
Right, and there are the requirements that agendas be posted outside.
Yes.
Right, things like that. So that the whole public has fair warning about the topics for the meeting.
Correct.
I mean, and I don't know is any of that new? Maybe just the posting requirements?
It wasn't new for the city of Lowell because our clerk's office had been pretty much doing that anyway. Our meetings had always been posted, as far as I know. But we have made other changes as well. Even the layout of the agenda is different. And a more recent change, and a good one, is the fact that all the communications now, instead of just being listed under the blanket of communications now appear as individual communications on the agenda. And again, that provides people with an opportunity, if they want it, to come down and speak on any one of these communications. So those changes have taken place as well.
Okay. I can recall a specific event. I don't know what the subject matter was, but I know it was prompted by somebody raising an issue that was raised in an anonymous email that I think most, if not all, the councilors were copied on, but it wasn't an agenda item. I'm not sure the manager was copied on it. Maybe he was, but I don't see how in any way could have, logically been construed as a communication from the city manager to the council, and yet it was discussed on the floor of the council for a half hour at least. So we have had issues, I think, and while I can appreciate, the sentiments of the motion to try and, maybe have the subcommittee be a check on this, councilors really need to police themselves and, follow the rules that are prescribed by law. It's a simple matter of that. And I think for the most part that takes place, but it doesn't happen always, and I think it's helpful to have a reminder. And somebody who's chaired these meetings, I'm sympathetic because other councilors and members of the public rely on the mayor to enforce the rules and the structure of the meeting in accordance with the open meeting law. And that gets frustrating at times if the mayor's always trying to rule that's not on the agenda, that's out of order. It creates the impression that you're trying to stifle debate when in fact it's just the opposite. You're trying to keep debate wide open for all points of view to be considered, and people have an opportunity to come and have their views heard. So, I think, you know, when laws change, those of us that have been here for a while and are used to the old systems sometimes have a harder time adapting than newer people who just learn the rules the way they are when they come. And so, I don't think we have a big problem with this, but I think we have had issues, and I think it's a good for us to all take it to heart that, with the open meeting law changed recently. There's been an emphasis on things being on the agenda. There's been, I guess, an emphasis on minutes to document those things now, and we need to be mindful of those things. Whether we need any specific rules, I think we're already governed by the rules, the rules of law. Yeah.
Yeah, there've been a few issues that have come up that have concerned me as to how it relates to the open meeting law. Obviously, we can suspend our own rules, but that doesn't give us the authority to suspend the open meeting law itself. And that has requirements of posting and allowing the public to know what's going to be discussed. If we suspend the rules and then allow other items to be discussed, then those members of the public were unaware and won't have time to participate in it. I do understand that there could be things that are time sensitive, but it should be clear to all of us that that's the case and that it requires some decision prior to the next meeting. And I could see then suspending the rules. So I know it was brought up, when this issue was brought up, that we would have to consider, A, is there time to deal with this at the next meeting? And we could have that motion or whatever on the agenda. That makes sense. Or was there time to file this in a timely manner before this? That would also make sense. So I think we'll have to, obviously, as Councilor Martin said, police ourselves, and we'll have to support the decision of the mayor in these cases where things are not on the agenda, and there is sufficient time to deal with it. It's not of an emergency nature. And so it would be better to have it on the agenda and allow the public to know we're going to be discussing it, and if they so wish, they'd be able to come down and weigh in on it by registering to speak. So I certainly agree with that. Basically, most motions should be filed in a timely manner, and generally there will be time. And even if it's not a motion, if we're going to be discussing it, again, we need to let the public know that that's going to take place. So I'd be supportive of following the open meeting law to the greatest extent possible. We don't want to leave ourselves open to any negative action by the state to enforce open meeting law, and that we should have the proper minutes that indicate everything was as it's supposed to be.
Thank you. Councilor Mercier?
Thank you, Mr. Chairman. I can remember one incident where I made a motion in regards to the UTEC 17-year-old vote, the vote for the 17-year-olds, and I made the motion, and it was of a time-sensitive nature whereby they were going to close the legislature was going to recess on like Friday, so we had to get that out very quickly. So that kind of, bend the rules a little bit with the time-sensitive issue. So that was the case where we really didn't have a choice. So I can understand that. If you make exceptions for things like that, I could understand that.
Okay. Councilor Leahy, did you want to add? No? Okay. Yes.
To build on that, and that's why it's I think the discussion is helpful in the long run. The point that Councilor Mercier has raised, there is this sort of open-ended language within the new open meeting law that allows communities to I forget the exact way they put it, but is to basically to the extent practical that if something new is going to go on the agenda and it hasn't been posted, to get it onto the agenda as soon as possible. And that was language actually that the mayor and I had questioned the attorney at the AG's office about and how they view that and how they interpret it. And again, it all sort of funnels down to a standard of if it's something that that could otherwise wait a week, or if there was some legitimate reason as to why a member of the council or even the administration couldn't have gotten it on the agenda, then perhaps steps can be made to get it before the governing body as quickly as possible, but then also take additional steps. And actually, I'm recalling an instance where we had done that, and I had checked with the Attorney General's office, and the fact that we were going to be putting it on, repeating it on the agenda the next week was something that they saw as the city taking as many steps as possible to ensure compliance with the open meeting law. But if there was a general understanding from the council as a whole that by and large, those are the exceptions and the rare exceptions, and that as Councilor Martin was saying, complying with the open meeting law really isn't that difficult. We just need to follow the agenda, and that will keep us in good stead.
Well, I guess I think that, the UTEC example is one that, for one thing, it was pretty, that's sort of everybody's on board with that, so that one's an easy one. The library letter, the anonymous letter, that was a little more difficult, but, once the chair lets that on, and then there's a discussion on it, then it wouldn't be fair if other councilors aren't then allowed to speak as well, and so you're off to the races, and that's why we ended up with 30 or 40 minutes. I guess I think that maybe there's two things that I can think of, and I think that Councilman Donson put it pretty succinctly, that, just because we're suspending the rules does not mean that we're suspending the open meeting law. And so maybe what would be a good idea would be that if a council wanted to suspend the rules, assuming that it wouldn't be a spontaneous thing that came up, but if they knew beforehand, and generally I think people do, that if they spoke to the chair, to the mayor about it, and then there could be a determination made that way. That seems to me to be, I think communication can go a real long ways, and I'm not sure that we are always communicating as well as we could. And so maybe that's something that we could do going forward is, if someone wants to suspend the rules, then they can bring it to the chair before the meeting and then make a decision on whether or not it's something that has to come up at that meeting, or whether it's something that could be suspended at the next meeting. Now, I guess if you're not happy with the mayor's ruling, that that's a different thing. But I think just going forward, and I'm assuming that the mayor would be fair about the whole thing and would use good judgment, and so that might be a good way to do it. The other thing is, since new rules came out in February of 2012, my recollection is that when the new councilors came in January of 2011, there was a little workshop held, and that they were given a lot of information by the DPD and maybe a review of the open meeting law at that time. And so was there a handout then?
Yes, for new councilors, we prepare a handout of the open meeting law guide, and we go over it, the council rules, as well as the state ethics.
But that would have preceded the changes that were made in February of 2012 regarding
Yeah,
it, right?
the changes that are, this last booklet are generally, there was nothing substantive changes. These are any sort of language changes, sometimes minor, sometimes substantive, that occur, and then they sort of republish the entire open meeting law. For the purposes of our discussions and the issues that we're looking at, nothing has changed since that original seminar, and nothing really has changed since the initial changes to the open meeting law with respect to the agenda and sticking to the agenda and things of that nature.
Okay, so is the handout something that you have handy, or is it?
Sure, I could make
something
copies and distribute it to the council. And it's also available,
online?
if the council wanted, it's also available online, if we wanted to save the photocopying. But either way, we can certainly get this, make this available.
Okay, so is that something that you think would be worthwhile, just as a little refresher for people?
Yeah, actually, what I can do is, I'll just give a summary of what the change is, what the update consisted of as well.
Okay. Does anybody have anything else?
One other point.
Councilor Martin.
Thank you. One thing I hear occasionally, which I think is never right, but correct me if I'm wrong, is while we're under suspension of the rules, you know, for reason A, let's talk about reason Z, right? That should not be. It should require a separate motion to suspend the rules for a new purpose. Am I right about that?
I believe so.
Yes.
And secondly, the other problem, the other obvious problem with that is it may be that there was a legitimate reason for suspending the rules for item A, but that same rule would not apply for other matters that followed.
Right, but I think Council Martin is correct. Suspension of the rules should be for that specific matter. It doesn't mean you go wildcat for that time and everything. It's wide open for everything.
Right, exactly. That offense would be, throw a red flag.
Mayor Murphy.
Thank you, Mr. Chair. Just to that point, I think that at some points, what has happened is, you know, we've suspended the rules, like I was saying before, to make just an announcement, not really talk substantively about some issue. And then that's kind of allowed for wiggle room to then launch into a substantive discussion of the issue, where it should have stuck really to just the announcement of,
Right.
You know, a future discussion. But to your earlier point, I'd be, you know, happy to, if people have something that they want to run by me before the meeting, that's fine. We can also do that during the meeting, which is also fine. And just really running it through that test of questions that each individual councilor can do themselves, that Councilman Donson mentioned earlier. Really, you know, is there any reason why it couldn't have been timely filed, or is there any reason why it can't be filed for the next meeting? To Councilor Mercier's question about the UTEC, if I remember correctly, there was actually an agenda item where it was allowed that you know, substantive discussion would be allowed on it. So anybody that really wanted to weigh in on that issue would have been present for that substantive discussion. And then, of course, you also had the mitigating factor of having to, you know, have some kind of action before that Friday or whatever it was. So there are different circumstances, but the purpose really behind this is just to get everybody on the same page, so that when I do apply the rules, that they're applied fairly and that people respect that.
I guess what I'm suggesting is that if Council Leahy, for instance, wanted to suspend the rules, if he was to approach you before the meeting and indicate why, then you could set the parameters of how far you would go with the suspension rules at that time. I just think it probably is easier and smoother to do it that way than to do it on the council floor with everybody during the meeting, that's all. You know, there might be times when it can't be done that way, but I think that when it can, that's the best way to do it. And I guess that's all I really mean by better communication.
Yes, thank you, Mr. Chairman. Let's say that over the weekend, the girls' cheerleading team at Lowell High School won a championship. I would almost want to suspend the rules and congratulate them. That would not be a problem, do you think? It isn't on the agenda and it isn't up for discussion, but in my pride, I probably would want to do that. Not that it happened, but I'm just giving that as an example.
I suppose that would be okay. Again, that would be something that you would take up with the mayor, but I also think there's nothing the matter with doing that a week later either, if it happens over the weekend. It's not, that isn't, you know, it's not too much, it doesn't become stale the following week to do that. And it might be able, you might be better able to do a little better presentation if it's a week later. But I mean, you have to use your own, you know, everybody's got to use their own judgment and common sense, I think, on that.
Very quickly to that point, this really applies to policy issues, you know, substantive policy issues. So, you know, if you're announcing something like Winterfest is happening this weekend, that's not, and it hasn't been put on the agenda, that's not an issue, really. But if something where, it would eventually lead to some kind of council action, then that's where you have to weigh things and make sure that you're in keeping with the law.
Okay. Councilman Mendoza?
Yeah, I was going to speak to that as well. If it requires a council vote to move forward with whatever's being discussed, then it probably needs to be on the agenda beforehand, or it lacks the time to be on the agenda. It needs immediate action. So that would be the case. But prior to that, the solicitor had offered to provide us a summary of changes to the open meeting law. I would ask that you also include either an electronic copy of the guide to the open meeting law or a link to it to all councilors. I know, like, in the current council that it's been provided, but being a member of the prior council, I wasn't privy to that. So my last version of that guide that was provided to me was more than 2 years ago. So I think by providing that link to all the councilors, it'll keep us all up to date. Appreciate it.
Are we good? You all set? Yeah. Okay. Anybody else? Okay, the chair would entertain a motion to adjourn.
I move to adjourn.
Motion to adjourn by Councilman Mendoza, seconded by Councilman Martin. All in favor, all opposed, means adjourned.